We will go on the record in the matters 24 CF 249, 25 CM 144, State of Wisconsin versus Cameron Chapman. The state appears through Special Prosecutor Aaron Marco by video conferencing. We have Daniel Repka, Defense Counsel, by video conferencing. We have Cameron Chapman appearing in person. We're set today in this matter for...
Here we go. Cameron Chapman, 22 years old, facing both a plea and sentencing in Wisconsin. Notice how the judge immediately makes sure he knows he can demand the attorneys show up in person instead of Zoom. That might sound small, but it's a constitutional safeguard. The defendant has the right to confront the state on equal footing. Chapman waives it, probably not wanting to drag this out, but it shows how thorough this judge is right from the start.
A plea and sentencing and an initial appearance. I believe the parties have reached an agreement. I have documents that have been filed in the matter. Mr. Repka, can you please recite the agreement that's been reached in these cases? All right, Mr. Chapman, that's the agreement you've reached with the state?
Yes.
And you see that Mr. Marco, as well as your attorney, Mr. Repka, they're both appearing by video conferencing. Do you understand you have a right to say, you know what, Judge, I want them both to be in the same room with all of us? Do you understand that?
Yes.
And they're both appearing by video. Are you okay with that?
Yes.
If at any time you have any questions or concerns and you need to speak with your attorney, let me know, and I can send you to our Zoom room, or you can call him on your telephone and get your questions answered, okay?
Okay.
All right. So I do have in front of me plea questionnaires, waiver of rights form, as well as a letter from DA Marco to Mr. Repka concerning the matter. And I believe I also have, and the offer. And I'm going to say, Mr. Marco, I just want to say I appreciate that you do that. It makes it crisp and clean and clear with what the court is to be expecting. So I appreciate that. So I have these plea questionnaire waiver of rights forms. Do you recognize the documents?
Yes.
Did your attorney go over these documents with you?
Yes.
Did he go over them thoroughly with you?
Yes.
Essentially word for word?
Yes.
And you understand everything completely?
Yes, ma'am.
And if you didn't understand something, did you ask him to explain it?
Yes.
And he did so?
Yes.
And you signed both of these documents?
Yes.
You are 22 years old. You have 12 years of schooling. You can read, write. You understand the English language. No drugs, alcohol, medications, no mental illnesses or disorders, correct?
Yes.
And did your attorney thoroughly go over with you what the state would need to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney thoroughly go over with you the maximum possible penalties you face?
Yes.
Did your attorney go over with you those constitutional rights on that first page?
Yes.
And do you understand them completely?
Yes.
Do you need me to go over them with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
This is the Miranda moment of a guilty plea. The judge is drilling Chapman on rights. He's about to give up jury trial, presumption of innocence, confrontation of witnesses. Once you plead guilty, the state doesn't have to prove a thing. And let's not miss the big one here: deportation risk if he weren't a citizen. These questions aren't just formalities, they lock the record so Chapman can't come back later and claim he didn't understand.
Yes.
Do you understand that here, as it relates to the resisting or obstructing an officer in 24 CF 249, the state would have to prove on or around November 30th, 2024, in Burnett County, Wisconsin, you knowingly resisted an officer while the officer's doing an act in an official capacity and with lawful authority. Do you understand what the state would have to prove?
Yes.
Do you understand maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
Do you understand that as it relates to the second count, the misdemeanor bail jumping in 25 CM 144, the state would have to prove on or around April 6, 2025, in Burnett County, Wisconsin, that having been released on a misdemeanor and having been released from custody with certain conditions, you intentionally failed to comply with those terms of your bond. Do you understand what the state would have to prove?
Yes.
Do you understand maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
Do you also understand that there is that agreement out there for a global resolution in which you would plead guilty to these two charges, and there's the recommendation for the court to place you on 2 years of probation with what's called a withheld sentence? Do you understand that's simply a recommendation to the court?
Yes.
Said differently, I don't have to follow it if I don't think that that's appropriate. Do you understand that?
Yes.
I could sentence you to the maximum possible penalty for each of these crimes, or I could do an imposed and stayed sentence, or I can do some conditional jail, anything, any combination of sentencing factors and tools. Do you understand that?
Yes.
Do you still wish to proceed and enter guilty pleas?
Yes.
And do you know what an imposed and stayed sentence is? Or do you want me to explain it to you?
I believe I do.
Okay. All right. So, do you have any questions for the court or your attorney before I proceed?
No.
Did you go over the criminal complaints with Mr. Repka?
Yes.
And there's sections in there, they're called the probable cause sections, where it basically says what happened those days and why you were charged with crimes. Do you remember that?
Yes.
For the most part, are those facts accurate?
Yes.
So are you admitting here today that you in fact did knowingly resist or obstruct an officer?
Yes.
And are you admitting here today that you in fact did intentionally violate the terms of your bond?
Yes.
Mr. Repka, may the court use the probable cause sections of the criminal complaints to find a factual basis?
Certainly, Your Honor.
Has anyone made any threats or any promises to you, Mr. Chapman, for you to plead guilty to these two charges? You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at these matters thoroughly?
Yes.
Are you satisfied with his services?
Yes.
Any questions again for the court or your attorney before I proceed?
No.
As to count 1 in 25 CM 144, misdemeanor bail jumping, how do you wish to plead?
Guilty.
As to count 2 in 24 CF 249, resisting or obstructing an officer, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those two charges. The other charges will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Repka, and please include if you have knowledge of his criminal history. Mr. Chapman, do you care to make a statement here today? Let me know anything that you want me to know about you, about this case, about anything. Okay. Mr. Chapman, you seem like a nice kid. I don't know if you have any substance abuse issues or anything like that that you're working through. Would you be honest if I asked you?
Yes.
You have some things you need to work through? You don't have to tell me exactly what, but...
A little bit.
And so, and with the misdemeanor bail jumping matter, I could tell, that's why I didn't increase cash, that was a very difficult and traumatic time for you with the loss of your friend. It's always hard to lose somebody you care about, but then to have a loss of somebody young and very close and somebody that you probably experienced a lot of life with makes it a whole lot.
Wow, this is where the courtroom turns human. The judge acknowledges Chapman's trauma, the loss of a close friend, and ties that pain to his bail violation. She's not excusing the crime, but she's putting it in context. That's rare. Judges often keep things strictly legal, but here she shows empathy while still anchoring back to accountability. Notice how she calls it forgivable, but not excusable. That's the balance of justice and compassion.
A lot harder. No excuse for violating the law or your bail conditions, but it's understandable. Okay, it's one of the more forgivable violations. Now, unfortunately, because of that and because of the other incident that got out of control that day with the custody issue, unfortunately, now you have conviction All right. I didn't hear anything about a possibility for expunction. Has that been discussed? To you, if you don't want to make that a part of the agreement, but the great thing about how I see it with those types of agreements is they're given a second opportunity to change their ways and to have things not affect their future. But if you don't think it's appropriate, Mr. Marco, I won't even address it, Marco. And I don't believe that there is any negotiation. I wanted each side's position, because if the DA's, the state's opposed, then I wanted to take that into account. As Mr. Marco stated, do you know what expunction is?
I have an idea of it.
It means that if you do all of the things the court tells you to do, and that means paying off all your fines and fees, doing the assessments, the programs, not getting in trouble while you're on probation. So that means as bad as it may hurt, you can't have a drink of alcohol. Those things while you're under probation. You have the ability, like that deferred judgment of conviction, to have it be removed from your criminal history, which with a young man such as yourself, who...
Here comes the golden ticket, expungement. If Chapman follows probation to the letter, no drinking, no violations, full compliance, his record could be wiped clean. For a 22-year-old, that's huge. Jobs, housing, future opportunities all hinge on that record. The judge is basically saying, mess up and you'll pay, but play it straight and you can get a fresh start. What do you think, too generous or the perfect motivation?
Going through some traumatic experiences, watching your mom in that situation, not easy. Any kid would want to, step in. And with the 22-year-old brain, you don't have the capacity to think as maturely as maybe you would have if you were 32 years old, and maybe you would have said, you would have had the thought, I don't believe my mom's being treated properly. I don't think this is right and correct, but we'll address that the proper route. Okay. And with the misdemeanor bail, that was trauma, but still you need to follow your bail conditions. I don't think you're a threat or a risk to the community. Again, I don't know the true underlying substance abuse issues you may be going through. If they're serious and they involve illegal substances, I want to make sure that you at least address that. Or if it's alcohol related, that you at least address that, because you're going to be a better member of the community, a better father someday, or because it wasn't your child, correct? No, a better father, a better brother, a better uncle, a better friend, a better significant other, all of those things, if you address those, and then if you do, and you're doing well, to not have the hump of a criminal history on your back, okay? So, again, I think you're a good kid who's going through some bad times. So what I'm going to do is I'm going to place you on probation. I don't think you need, honestly, 2 years to figure this stuff out. So I think I'm going to put you on probation for the period of 1 year, but that gives you 1 year to get all of these things done and completed, and to get to better. Not to get to fixed, not to get to cured, because that's not going to happen. No one can do that. It's just get to better and on a more positive path. Okay. So 1 year of probation. What I'm going to do with fines and fees is I'm assessing $443. That would be for the resisting, obstructing. For the misdemeanor bail, I'm only going to assess the DNA surcharge. I'm waiving the other fines and fees. You have $350 posted, so that means a little less than $300 you're going to have paid, and you're going to pay that to probation, not to the court, unless you can pay it today. If you pay it today, you have less probation fees, like collecting fees and those things, but I either need a guarantee that it'll be paid today to my clerk, or you have to pay through probation and there'll be additional fees, you'll have to pay them. But it's because I am going to give you the ability to get this expunged. to get it removed from your criminal history if you do all the things you need to do, okay? So do you have the ability to pay it today? And it's fine if you don't.
Yes.
Okay, because that'll just save some fines and fees. You'll still have some probation fees, but it'll save you some collecting fees and those kinds of things. So you're going to pay it today. Good. One thing less you need to do for the future. What the conditions of probation: absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, regular drug and alcohol testing. Okay. I'm going to have you do an AODA assessment and follow through. All right. So do you know what that is? Have you had to do that before?
I believe so.
And you're going to do it again, and then you're going to take it. Not that you didn't take it seriously before, but now you're going to take it even more seriously because there's even more things on the line. You're going to do all that's recommended until that's completed. Okay. I also would like you to have a mental health assessment, a therapy assessment. Go to a therapist. I think you're struggling. Okay. You don't have to continue with therapy forever. If they say, you know what, why don't you come back a couple sessions, then that's what you need to do. If they say, no, you're fine after the session, you can determine if you want to come back or not come back. That's up to you. I just think it would be good to at least go over these things in at least one session, okay? Because you are struggling. There are some emotional things that are going on inside of you. So you're going to have the whole year to complete those things. However, the sooner you get it done, the better, all right? And if this is not what the court can order, but if you get these things done and you reach a satisfaction to probation that you're doing well and you're on a good path, I have no objection to them saying, you know what, Judge, he can get off of probation early. All right? That's up to them, though, to determine if you've reached that point. But I'm only going to place you on probation for a year. You don't have a criminal history. You just have some things you're working through. So I don't think, again, that it's something that it needs to be too long. All right? I'm really hoping you're going to do all that you can, and you're going to do some reflection. All right? So you have, with regards to that, I think that's all. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. You're going to pay the $300, or it's close to $300 that's still owed today to the clerk. Failing to do that, not only will the court enter a civil judgment, but you will get a warrant. You could sit up to 6 months in jail. I'm not doing a withheld sentence. Here's why. I understand that people like that, attorneys like to have withheld sentences. That means that the court can sentence you all the way up to 9 months for each charge, so could be 18 months of jail. Based upon the things that I have in front of me, they're not that serious. The resisting, obstructing the officer is the more serious one. And following bond conditions is serious, but under the circumstances, I understand. So what I'm going to do with regards to each of the convictions, I'm going to order 45 days of jail concurrent. All right. So if you're revoked, you have to sit 45 days in jail. I don't think you're going to like that. I don't think you're going to want to do that. The punishment.
And here's the hammer hanging overhead: 45 days in jail if Chapman blows probation. That's the judge's insurance policy, gentle guidance paired with a sharp stick. Probation plus the threat of jail is classic judicial leverage. It's not the harshest sentence, but it keeps Chapman walking the straight line. Think about it. Is fear of jail a better motivator than probation alone? Drop your thoughts in the comments.
It needs to be only as severe as the facts and as the totality of the circumstances, your history, who you are, and all of these things. The crime is serious, but this isn't the most serious. And again, I don't think you're going to want to go to jail for 45 days. So that's the hammer hanging over your head. So you have 20 days to appeal. Failing to appeal means you will lose that right. I do need to order your DNA. So you're going to need to go to the sheriff's department when you're done, provide the swab, and then when you're done there, immediately go and report to probation, okay? Get that all set up. Are you still on Burnett Road?
Yes.
And Telephone number I have ends in 0296.
Yes.
Okay. Again, come here, go pay your fines and the rest of the fines and fees, go provide your DNA, go report to probation, and then you're good to go, okay? Set up your assessments as quickly as you can, because then, you know, you can be on your way and maybe to a point where you can get off of probation, okay? All right. Anything that I'm missing, Mr. Marco?